I'm getting sued for stealing wine? I have to go to court?
All rise.
Thank you. Please be seated. Good afternoon. Court is now in session. I am Judge McCrary, and today's case is the state of Florida versus Clarence Gideon. Is the prosecution ready?
Yes, Your Honor. Yeah.
Mr. Stone, you may open the case.
Yes, thank you, Your Honor. May it please the court that the state intends to demonstrate beyond a reasonable doubt that the defendant, Clarence Earl Gideon, did willfully and unlawfully perpetrate the felony offense of breaking and entering with the intent to commit petty larceny, as evidenced by eyewitness testimony placing him at the immediate vicinity of the premises at the precise moment of the unlawful intrusion, thereby establishing not merely presence, but the conscious participation in the criminal enterprise. The evidence will show that the defendant was observed departing the scene in temporal proximity to the commission of the offense, and that such proximity, coupled with the corroborative testimony, forms a compelling nexus between Mr. Gideon and the unlawful appropriation of such cash and alcoholic merchandise from the establishment in question.
Can I get a lawyer, please?
Request denied.
I don't got a clue what he's saying. Don't I have to get a lawyer in here or something? Can I get a lawyer in here? Doesn't the Constitution?
The Constitution does not require this court to appoint counsel in non-capital cases. Your motion is denied. Please continue, Mr. Stone.
Ladies and gentlemen of the jury, facts before you are neither speculative nor ambiguous. The defendant was observed departing the premises at the precise moment this unlawful intrusion occurred. His presence was not incidental. It was contemporaneous with the commission of the offense.
Judge, it wasn't me, I swear!
Sit down.
As I was saying, the state has presented credible eyewitness testimony, corroborating circumstances, and an unbroken chain of events leads directly to Clarence Earl Gideon. The defendant, despite his attempts, has offered no persuasive refutation of these facts. Suspicion has matured into certainty, and certainty, under the law, compels but one conclusion. The state respectfully requests a verdict of guilty.
Has the jury reached a verdict?
Yes, Your Honor. We find the defendant guilty.
Clarence Earl Gideon, being found guilty of breaking and entering with intent to commit petty theft, this court hereby sentenced you to 5 years in the Florida State Prison. Court adjourned.
Well, that didn't go so well.
To the Supreme Court of the United States. My name is Clarence Earl Gideon, and I am writing this from the Florida State Prison. I was charged with breaking and entering, and when I went to court, I asked the judge to appoint me a lawyer because I couldn't afford one. The judge told me that the court could only give lawyers in cases where a man might be put to death. And since my charge was not that serious, I would have to defend myself. I believe that every man, no matter how poor he is, should have a lawyer when he stands trial. Without one, I do not believe a person can truly stand a fair chance. I respectfully ask this court to review my case and decide whether my rights were denied. Sincerely, Gideon.
The Supreme Court of the United States is now in session. We will hear an argument in Gideon v. Wainwright.
This case concerns Clarence Earl Gideon, convicted of felony breaking and entering after being denied appointed counsel because the charge was not capital.
The constitutional issue before us is whether the Sixth Amendment right to counsel applies to state courts through the 14th Amendment.
And Mr. Chief Justice, may it please the court. The state of Florida maintains while the Sixth Amendment guarantees counsel in the federal courts, it does not require states to appoint a counsel in every felony case. States must have discretion to determine when a counsel is necessary to ensure fairness.
Counsel. Is the right to counsel fundamental to a fair trial?
It may be helpful, Your Honor, but it is not indispensable in every case. Some trials are simple enough for the defendant to represent himself.
Even when liberty is at stake?
Mr. Fortes, you have the floor.
Mr. Chief Justice, and may it please the court, this case asks whether a poor man charged with a serious crime can be assured a fair trial when forced to defend himself against a trained prosecutor. The Sixth Amendment guarantees the assistance of counsel. That guarantee is meaningless if it does not apply in state courts, where the vast majority of criminal prosecutions occur.
And your position regarding incorporation?
The right to counsel is fundamental and essential to a fair trial. Therefore, under the 14th Amendment's Due Process Clause, it must apply to the states. Our system is adversarial. It assumes that both sides are represented by trained advocates. Without counsel, the defendant lacks the skill to test evidence, object to improper testimony, or safeguard constitutional rights.
You know, I think he's made a fair point about being able to have a lawyer, because I think it's pretty unfair to be your own lawyer.
I would agree.
Yeah.
The court holds that the right to counsel is fundamental and essential to a fair trial. The Sixth Amendment guarantees that if counsel is incorporated through the 14th Amendment and applies to the states, lawyers in criminal courts are necessities, not luxuries. The judgment of the Florida Supreme Court is reversed.
In our adversarial system of justice, even an intelligent, educated layman has small skill in the science of law. Without a lawyer, a defendant faces the danger of conviction, not because he is guilty, but because he does not know how to defend himself. A fair trial cannot exist where only the state has counsel. Court adjourned.
Well, that didn't go so well.
And now, the least helpful member of our group will give us a history lesson.
In 1973, the Supreme Court unanimously ruled in Gideon v. Wainwright that states must provide attorneys to criminal defendants who cannot afford them. Clarence Earl Gideon was retried with a lawyer and was acquitted. This decision transformed American criminal justice. It required states to create public defender systems to ensure that poverty would not determine access to justice. The ruling strengthened the incorporation doctrine, expanding the application of the Bill of Rights to the states. Gideon built upon the earlier case of Betts v. Brady, which had held that states did not have to provide attorneys in most felony cases. In Gideon, the court overturned Betts, declaring that the right to counsel is fundamental. The impact was immediate and lasting. Public defender offices expanded nationwide. Millions of defendants gained access to legal representation. Gideon v. Wainwright remains one of the most significant criminal procedure decisions in American history, reinforcing the principle that justice in the United States must not depend on wealth.